General Attorney General, congratulations. You are the youngest Attorney General in the history of Ghana. And you started this job 2 years ago, isn't it? Must have been challenging.
Well, definitely, it is challenging in view of the constitutional mandates of the Attorney General. The Attorney General is the protector of the public interest, and that, of course, places the onerous duty of ensuring that whatever is right for ensuring sound administration of justice is secured. And because you see the Attorney General is placed in a situation where he's a principal legal advisor to the government, is constitutionally designated as a defender or the defendant in all civil proceedings against the state. He is also responsible, solely vested with prosecutorial authority in the Republic. So clearly, I mean, this places the Attorney General right at the heart of government, and his functions are no doubt crucial to the sustenance of good governance, sound administration of justice, rule of law, and what have you. Of course, armed with the equipment, relevant equipment, as I would say, by the Most High Lord Almighty, we always overcome the challenges.
Is it true that all successful lawyers, when people start practicing law and they are successful, they either want to be Attorney General or Chief Justice? So the history is long. Joe Randolph, Akufo-Addo, Joe Garte, Ayuko, Betty Moldidrisu, Martin Amidu.
Yeah.
Did you start thinking at the time you started practicing and seeing some success that maybe one day I want to be Attorney General?
I think first and foremost, the Attorney General, no doubt, is the leader of the bar. So if you're a member of the bar, no doubt, you would aspire to be the leader of the bar. Of course, in terms of the dispensation of justice, the Chief Justice is also the ultimate in terms of justice delivery. So these two positions, no doubt, are at the very top. At the bar, the Attorney General is the leader, and on the bench, the Chief Justice is the leader. So yes, it's natural for one to aspire to be like that. Of course, I found myself on the path of conducting many cases of public importance, public interest, and law when I was in the law firm of Akufo-Addo and Co. And I think somehow, I mean, at every stage, I must say, at every stage of my appointment, either as Deputy Attorney General or as Attorney General, somehow the President, in all humility, said, well, you earned it. So perhaps, maybe, my line of practice got me into this position. And of course, I also had the aspiration right from the beginning. So
let's talk about the role that of Attorney General that you talked about as a defender of the public, defender of rights.
Right.
People say their monies have been locked up in what the government calls debt exchange program.
Right.
They are referring to a certain advice that you gave, that you have told the government to pay them their money. Can you give us the context of that advice that you've given? That they say, that Attorney General says it's illegal for governments to hold our money for individual bondholders. They say they want their money. They say government says they cannot give them their money in the budget. But they say the Attorney General says that government should give us our money. What is the context?
Well, I think the context is that the opinion was delivered on the strength of a request by the Minister of Finance. And I found it quite interesting that the Minister of Finance is a request for such an opinion, because in their letter, they actually recognize the fact that various options that would be explored, possibly explored by them, may encounter some legal challenges. So one option was recourse to executive action by the government exercising, or the President exercising powers under Article 31 of the Constitution, or perhaps Article 21 of the Constitution, which relates to curtailment to the rights of persons, to impose such a measure on the bondholders. And they themselves recognize that it may be fraught with some challenges. Another option was also by the Minister for Finance exercising his powers to enact a subsidiary legislation, some kind of constitutional instrument or an ally to regulate the bondholders and all. And they felt that that was quite onerous and it will require my opinion on it. And then, of course, they also explored the question whether a voluntary engagement to the bondholders would also serve the end that was required. And then they actually also explored the question whether Parliament could also be prayed to exercise its legislative powers to enact legislation to curtail the rights of bondholders. And so I delivered an opinion in respect of all the issues. Now, first point that I made was that in terms of the exercise by the Minister of Finance of his powers to use the subsidiary legislation to curtail the rights, as it were, of the bondholders, that will have to be done within the context of the relevant laws governing the Office of the Minister for Finance. The Fiscal Responsibility Act remarkably gives the Minister for Finance the power to ensure fiscal discipline, and it vests the Minister for Finance with the power to use regulations to ensure fiscal discipline, and that would entail that the Minister for Finance could enact regulations in the form of a subsidiary legislation, a legislative instrument, to perhaps curtail certain rights when it comes to, or in terms of an adverse financial situation. I took the view that the power to enact regulations must be on the strength of a specific provision in the law, the primary law, that's the substantive legislation. So you cannot enact legislation or subsidiary legislation and ally to affect anybody's right when the substantive legislation on the basis of which the LI has been enacted does not closely with that power. And I saw the circumstances within which the Minister for Finance may exercise his powers to enact such regulations under or by the combined effect of Section 7 and 3 and then 1, as well as even 2 of the Fiscal Responsibility Act, as not permissive of such a procedure. And then also in terms of the recourse to executive action, my view is that yes, the President has the power to declare emergency situation, but of course that power is exercised within the circumstances set out in the Constitution itself. So those relate to natural disaster, route, and other such emergency and all that. And really, so this situation that we found ourselves in was not within the premises of such a provision. Then also under Article 21, which is the power of the President to curtail fundamental human rights and all that. Of course, that is first of all subject to provisions spelled out in Article 21 itself, and also that did not give basis or a foundation for such a recourse. And then generally, the power of Parliament to enact an act of Parliament to regulate or affect such a situation. The power of Parliament to enact legislation itself is subject to restrictions imposed on Parliament by the Constitution itself. So refer to Article 107 of the Constitution, which talks about, or which prohibits Parliament from enacting legislation which will adversely affect the rights of persons, or which will operate retrospectively to impose limitations or burdens upon people. So that such legislation clearly will be caught by the requirements of Article 107. So Parliament will be restrained in enacting such legislation. Also, Article 18 and Article 20 of the Constitution, which talks about property rights and all. Yes, because a person's bond or money is a person's property, and therefore legitimate constitutional questions can be raised as to propriety of such legislation by Parliament. And so ultimately, I took the view that if you need a bond instrument, the bond instrument is the nature of a contract. And of course, the manner in which the contract can be varied is subject to the common law principles of amendment of contract, which is that a party must agree to amend the terms of a contract. And unilateral modification of the terms of a contract will be declared void if it is not subject to the agreement of the party. And I felt that really, yes, voluntary engagement was the best way possible. And I think it's very pertinent to place on record that Parliament, the Minister for Finance, actually operated within the premise of the opinion
but people are saying that they have not been consulted, that they have not been engaged to have a voluntary amendment of their contract, that they want their money. The government is telling them that under the debt exchange program, one of the categories that will not receive their money for 2023 is individual bondholders. They are saying now that they want their money, and they are saying, you said they can have their money.
No, I didn't say they could have their money. The effect to the opinion, I see a copy of it before you, is what I stated. So I think that, yes, if I may.
Let's look at what you said.
So the effect to the opinion is that, yes, the Minister for Finance can vary the terms, but of course subject to agreement by the bondholders.
So without
that they cannot be, yes, there cannot be a unilateral imposition of the terms on the party.
So the budget that's gone to Parliament contained that announcement.
Yeah, I think, yes, so these are projections by the government of Ghana. Yes, I would think that, yes, it could be projections, yes. So in respect of the first question, the legality of a unilateral attempt by the government to introduce collective action clauses, which is a decision by a majority to affect the rights of the minority into the bond. I stated clearly that a traditional contract doctrine forbids the unilateral modification of contract and treats a proposed unilateral modification as an offer that is not binding until accepted. So if you want to unilaterally modify the terms of the contract,
if they don't accept it, government cannot proceed.
Yeah, I think it's in essence, and I think
the deadline for,
precisely. So that clearly
for continuous voluntary negotiation.
Yes. So that clearly indicates the engagement, the acceptance. Yes. Yes, the government is engaging.
So the route that you're advising government on is that yes, you can verify, but you have to have their permission to do so.
Yes, and from where I sit, I'm aware of series of engagements by the Ministry of Finance or the relevant stakeholders. Indeed, even before this opinion was solicited, as part of the engagement, which of course did not end with only government institutions or government agencies. The IMF people had actually been to my office a number of times. We had various discussions and all. I stated the same position to them and all. So this opinion was only a confirmation of discussions that we had held.
But right now
I remember, yes, so and I'm saying
that's why they are saying that.
Yeah, but I'm saying that even
we should say yes.
Yeah, but I'm saying that even the decision to extend the deadline for acceptance of the terms itself is indicative of the engagement process that has gone on. So clearly engagement is going on. So I do not see any departure from or variation of the terms of this opinion by the Ministry of Finance. I mean, I think that they're operating within it.
Yeah, but and the question, they are not happy to engage in that regard. They want their money. So they don't want to vary the terms.
Yeah, so I think that ultimately, yes, as I said, an imposition will not be proper. So I think the engagement could result in a decision by the Ministry of Finance, which is the appropriate body vested with decisions over matters of finance. Even in this office, when it comes to matters of finance and all, will indicate as part of our opinion that refer this part to the Ministry of Finance. So the Ministry of Finance will ultimately, as a result of the engagement process, decide whether to agree to what you say, give me my money or not.
Well, but the people are preparing to now petition to you that we don't want to engage. We want our money for 2023. And you said that without our buy-in, our say-so, government cannot unilaterally impose the new debt exchange program on them. That means they are the stronger party, not government.
Well, I am aware of various actions that have been threatened, and perhaps that have also been announced as having been taken, even though I'm yet to be served with a specific rate of summons on application to the courts of Ghana. So I think that, yes, the people, with all respect, are at liberty to make any kind of request. But I'm saying that there must be reasonableness in this situation. There must be reasonableness having regard to the circumstances within which we find ourselves and all. And I'm also saying, secondly, that it's a Ministry of Finance which is vested with the mandate to determine matters of finance. So, yes, whether Ministry of Finance will agree to the request for the individual bondholders to be excluded or not is one for the Minister for Finance.
But you will urge the individual bondholders to be what, patriotic at this stage?
Yeah, I would say cooperation. I think this, and that's one thing that I've always wanted to make one point out. The circumstances within which we find ourselves. I'm not trying to reiterate any point that has been made as part of the political response at all. But indeed and in fact, globally, all these hardships and circumstances are attributable primarily to the limitations that were imposed on the world by the COVID-19 situation. I was in the United Kingdom when the SR Prime Minister of the United Kingdom took office, Liz Truss, in September. And remarkably, she cited two factors as responsible for the economic challenges of the United Kingdom. And those two factors, it's worthy to note, are the COVID-19 situation and the results of the Russia-Ukraine conflict. And I found it quite remarkable because we were in Ghana, I had just come from, traveled from Ghana to the United Kingdom on some official program, and then the swearing in of the new, the assumption of office of the new Prime Minister happened. And of course, we all took an interest in it. And I listened to the speech live. And I found it quite remarkable that she, in the United Kingdom, will be citing these two major factors. And this is a factor that was roundly accepted by the people of the United Kingdom and all. So how much more an economy as fragile as Ghanaians. So I think it cannot really be some kind of political response on the part of the government when these two factors are cited for the circumstances within which we find ourselves. Yes, the war in Russia and Ukraine may seem far, but the effect really felt here. And I think we must all cooperate and at this time see if it's possible for us to come along. We come along as much as possible. And I trust this government, of course, to come up with the right economic solutions to the problem.